5 seconds to go. Start. Mr. Luthra pointed out that Rule 4 of the SEBI Adjudication Rules 1995 provides for a two-tier adjudication process. The said rules is in pari materia with Rule 4 of the Foreign Exchange Management Adjudication Proceedings and Appeal Rules 2000. Rule 4 of the SEBI Adjudication Rules 1995 contemplates that the adjudicating authority is first required to form an opinion on the basis of the reply to the show cause notice as to whether an inquiry should be conducted against the noticee or not. Even after forming the opinion, the adjudicating authority cannot proceed to the stage of final hearing without first issuing notice to the petitioner for explaining the charges against him and then giving him an opportunity to produce documents and examine witnesses. It is submitted that, in this case, the adjudicating authority has not followed the procedure and instead fixed the case for final hearing without forming an opinion as required under Rule 4.3 of the SEBI Adjudication Rules 1995. In the context of his argument, Mr. Luthra relied on the decision of the High Court at Bombay in Shashank Supra, upheld by this court in SLP Civil number 01704 of 2014, titled Union of India versus Shashank. In Shashank Supra, the High Court held, it is true that ordinarily this court would not entertain a writ petition against a show cause notice, as the noticee would get an opportunity to submit his reply and of hearing before the adjudicating authority. However, the scheme of the adjudication rules in question is different from the other inquiries where an authority issues a show cause notice, the noticee submits his reply, the authority then hears the complainant and the noticee for taking a decision in the matter. Ordinarily, inquiries are not divided into different stages, unlike the inquiry for which procedure is laid down in Rule 4 of the Adjudication Rules. In ordinary inquiries, the inquiry officer is not required to form any opinion before conclusion of the inquiry. On the other hand, the scheme of Rule 4 of the Adjudication Rules is quite different, and the same is required to be examined both for the purpose of considering the last alternative submission of the petitioner about breach of Rule 4 of the adjudicating rules and also for considering the aforesaid preliminary objection raised by the learned additional Solicitor General about maintainability of the writ petition. On reading the above rule, particularly sub-rules 1 and 3 thereof, it is clear that on the issue of show cause notice, a noticee is permitted to submit his reply to the same. In terms of the above rule, the adjudicating authority has to consider the objections raised by the noticee, and only if he forms an opinion that an inquiry should be continued further, that the adjudicating proceedings can be proceeded with by issuing a notice for personal hearing. However, if the adjudicating authority is satisfied that the objections raised to the notice are valid, he may drop the show cause notice. The provision as found in Rule 4 of the adjudication rules is a unique provision. The counsel for the parties were not able to point out any similar rules under which a two-tier adjudication of a show cause notice is provided for in any other statute. Normally, Once a show cause notice has been issued, the adjudicating authority deals with all the objections of the noticee, be it preliminary as well as any other defense, by passing one common order of adjudication. Stop.